Our first case this afternoon is People of the State of New York versus Raymond Leach. Mr. Feldman, welcome.
Thank you very much, Your Honor. The post-plea waiver that was used in this case should be banned by this Court.
Before you go too much further, would you like any rebuttal time?
2 minutes, Your Honor, please. Thank you. The appellate waiver that was used in this case is unenforceable because it was not made part of the pleading calculus.
Well, it was mentioned. It's funny that the district attorney's supplemental record is larger than yours. And one of the things that they included, I think it was on page 9 of the record, although it was part of yours, was that the judge said to him, and you will waive your right to appeal, and he said yes.
That's correct.
That was at the plea.
But that, Your Honor, is not sufficient for a knowing, intelligent, and voluntary appellate waiver because the judge has not informed the lay defendant, in this case a defendant who had mental problems, of his rights. And the appellate rights are so vitally important.
What else did the judge need to say?
Well,
given our decision in People v. Saunders, what else?
Well, what the judge should have told him is that that his appellate rights were very important, that they would be foreclosed if he entered into the appellate waiver. He should have discussed various factors in his background to make sure that he understood the import of the waiver, and the Court should have spoken to him in plain English about what the appellate waiver meant.
So, Counsel, I'm sorry, you said that the judge should discuss various factors in the defendant's background. Are you saying every judge should look at each defendant's background?
Well, in this particular case, because of the competency issue, the judge should have explored that issue.
I didn't think you raised the competency issue on appeal.
Well, we're raising the appellate waiver issue.
Well, that really isn't the same, though, as his competency.
That's true.
Yeah.
But one sentence is completely inadequate to
I tend to think, speaking only for myself, you may be right as to that issue. And also assuming that that's all that was done at the plea, and then at the sentencing he signs a written waiver, but by then he's already waived the right. So he should have done it before. I understand that argument. Oddly enough, in this case, though, this same waiver procedure was done by the same judge, and it seems to have been found invalid a number of times in the Second Department before, except for this case. Is there something special here that I missed?
That's not correct, Judge.
Okay.
As a matter of fact, in People v. Gill, which we argued in our firm, the Second Department found the appellate waiver ineffective. It's 109-83rd 484.
Well, I said invalid. You said ineffective. Okay. Go ahead.
He was agreeing with you.
Right. Right. Well, but what I'm saying is that the Second Department has, in a roundabout way, said that the post-plea appellate waiver is ineffective precisely because it doesn't fulfill the purpose of what a waiver should be, knowing, intelligent, and voluntary.
And in those cases, did the judge also give this one
phrase,
it was the same
one
judge.
sentence?
In those other cases, the judge also asked at the plea, do you waive your right to appeal, and nothing else?
In Gill, same judge, same strategy that the judge used.
The judge also asked, as you did here, have you talked to your attorney about these?
No. And he didn't hear either. He
did hear, yes. Did you speak to your attorney?
But the point is that, Your Honor, that...
Well, no, does that make a difference?
It does.
So you're waiving your right to appeal, and then you ask, did you speak to your attorney? Does that matter? Does that make it different from just saying, do you waive your right to appeal?
It does.
Okay.
But, as I said before, I don't want to belabor the point, but one sentence is insufficient. The Second Department recently ruled that because of the enormous number of appellate waivers that have been found unenforceable, they announced a series of rules that trial judges should now follow, and it is very, very divergent than what happened in this plea.
If the order of what happened had been switched, would we be here? Would you be challenging that?
Your Honor, if it had been switched, then this would not be an issue, because
So you're not challenging the colloquy and the written waiver and all that was perfectly fine. It was just done too late.
Yes.
I just want to make that clear.
It was too little, too late, and the reason.
Well, you said too little, too late. That's one of the things I'm trying to just hone you in on.
Right.
Was it too little, or was it just
It was too little because it didn't comply with the Second Department's rules about what trial judges should tell a defendant.
That's where I want to pick a bone with you on your record. You know, that your appendix left out, you know, pages 5, 6, 7, where he goes through better than almost anyone we've had. You know, he goes through every single. Do you understand that under the Constitution of the United States you have a right to be silent or privileged? And on every single one, I'm going to get there. I know you're going to talk about this waiver, but after he goes through all of these, which you didn't include in your appendix, he says you have a clear brain. Is that right? Yes, good. You must meet with probation and cooperate with them at your pre-sentence investigation. You must be here on the date that I set this matter down for sentence. You must waive and give up your right to appeal. Do you understand this plea promise? So he was telling him that you're going to have to, you know, sign this waiver when you come back for sentencing. Now, I'm not sure it was right or wrong, but he certainly understood, it seems, what was going on.
No, because he wasn't explained at the plea. I'm not talking about the sentence.
Right.
The only way a defendant can enter a knowing, intelligent, and voluntary plea when the people ask for an appellate waiver is to understand the full dimension of what he's doing. And that's the reason why one sentence at the plea is insufficient, because it's not part of the pleading calculus.
Well, he got to appeal anyway, right?
Yes.
So he's up. In fact, he's up here.
Yes.
What struck me, too, was I went back, I think was part of the record, was his pro se brief at the appellate division. And he laid out in minute detail what happened here. And at the CLA, when we were talking about this, I'm not sure a crime was committed. And yet the defense counsel, you know, breezed right by that. In fact, essentially said, yeah, he admits he did something wrong, but he did it for the right reason or something. But no one, did anybody talk to these people? I mean, you've got a health place that threw these records in a dumpster. And all of a sudden he's guilty of something because their defalcation. And I know you were getting ready to talk, but I'm thinking, who did this? They admit this. They admit that they threw these records out, and they say, he says, that they invited him. He couldn't think of a figure. He wanted these people to be able to sue the health department or the health organization. And she's the one that said, if we give you $10,000, will you review? So it wasn't like he was extorting this 10. And then when the CFO turns out to be the police chief pretending to be a CFO, and they arrest him the minute he accepts the check, it just seemed to me there were so many questions in this case. And
Your Honor, that really is a brilliant analysis of this case. You basically took my entire argument right there.
That was his brief. That was his brief at the appellate.
And what this case does in the Second Department, because no crime was committed, was a
So his
criminal.
plea to extorting money from the center was false?
No, Your Honor, there was no extortion. A negotiated arm's length agreement for a finder's fee is not a criminal act. There is no mens rea, there is no taking, and therefore there is no attempted grand larceny.
So if you drop your wallet, you go outside, drop your wallet, I find it, I call you, and I say, you want your wallet back, you got to give me $2,000. Is that extortion?
If the
Or is
wallet
that,
has
I'm asking for a
$100,000
reward?
If the wallet has $100,000 and we negotiate, which I would not do.
What was the negotiation? What was the negotiation? I told you this is what you need to do to get the money back. Where is there a bargaining position and that we're negotiating, and that...
Well, it's a finder's fee. And what
Did
this...
I say that?
Did who say it?
In my hypothetical, have I said it's a finder's fee, or have I said, you want the wallet back, you got to give me $2,000? Is that a demand for a reward? Or is that extortion? If you ever want to see this wallet again, if you want it back, you've got to give me $2,000. Does it mean something?
Didn't he threaten to file lawsuits? Does that change the equation at all?
No, because it's just a negotiating strategy to enhance a finder's fee.
Well, I guess the point is that was an argument that wasn't made at the trial level. I mean,
That's correct, because there was a plea.
Right. And is that
But the defendant pro se said to the judge that he did, when the judge asked him if he committed a criminal act, is that a fair statement? He said, that is not a fair statement.
Well, then
He did not commit a crime.
He made further inquiry, didn't he, the court?
But the judge didn't. What the judge did was what he did not make. There was a duty to inquire once there was a denial of guilt. And what the judge basically did was bullied the defendant and asked the same question again.
Well, there was an off-the-record discussion between the defendant and counsel before the court asked the question again, correct?
That's correct.
Okay, so it wasn't just, I'll ask you once and you gave me the wrong answer, I'll ask you again.
But that's really what happened. It depends how you define a duty to inquire. But when the judge is just repeating the same exact question, instead of saying to the defendant, you tell me why you feel you haven't committed a crime. And the lay defendant wasn't in a position to articulate this type of...
Doesn't counsel later explain that it's that the defendant didn't understand that even if he got no material benefit, that it could still be attempted grand larceny by extortion? Wasn't that what the counsel was trying to explain later in the colloquy?
I don't think the defendant...
And the judge says, yes, there's no Robin Hood defense?
Well...
And counsel says, the defendant
now
understands,
that's between the judge and defense counsel.
The defendant is present, right?
Right. But the issue here was not a Robin Hood defense. That was never...
I thought that was when he was saying he was going to give the money to someone else. So he was robbing from the poor and giving it to... So robbing from the rich and giving it to someone else, the middle class. And that was the core of his Robin Hood defense. That's what I understood that argument to be. That seems relatively straightforward. What I don't understand is your argument that you're talking about the Lopez exception, and whether or not the Lopez exception applied, and the court says to him, just given the GHVFC, the records, if he had found them, why he should have just given them to them when he found them, and the defendant responded, that's not a fair statement. And you're saying that invokes the Lopez exception? That's the way I read your brief. Go ahead.
What I was arguing was that this plea falls under the rare case exception because there is a denial, an explicit denial of guilt.
So when you're saying, so I'm clear, you're saying when he says that is not a fair statement, he's denying guilt?
Yes.
What's the element he negates?
Theft. He didn't. There was no stealing. There was no taking in this case. It was a negotiated finder's fee.
That she suggested, that the health department, health agency suggested. They said, if we'll give you $10,000, you give us the records back, right? The appellate division said that this is ripe for a 440. That there are some facts that are not on the record that it would seem appropriate for a 440. Do you know if one's been filed?
I believe he filed a 440.
Okay.
I'm not aware of what the contents are.
Yeah. Okay.
But I see my time is up.
Yeah, we'll catch you on the.
Okay. Thank you very much, Your Honor.
Thank you, sir. Ms. Schultz, welcome.
May it please the Court, my name is Elizabeth Scholes. I represent the people in this matter. I'm here to discuss with you today why I believe that the defendant's conviction should be affirmed.
Can I ask you a question about the waiver issue? I'm questioning whether we can reach the validity of the appeal waiver issue, because do you agree that if the defendant is correct, that he negated an element of the crime, the plea wasn't voluntary, and it has to be vacated? But if he's not correct, then the issue of the appeal waiver is unpreserved. Do you agree with that?
I believe so. What we argued was that he, if he's challenging his plea as involuntary, then the issue of the waiver is really irrelevant, and it would, for this court to decide the issue, it would basically force the court to issue an advisory opinion, which I don't believe that this court would be able to do in this instance. So really the heart and...
So if we go to the plea waiver, we've got to address it. The voluntariness can never be waived, so it doesn't really matter. It's irrelevant, is your point.
If that's truly what the defendant's arguing, but he makes multiple arguments, at least insofar as the waiver is concerned, our opinion is that it's really a procedural argument that if he doesn't object to, it can be waived. He really makes no valid challenge to the sufficiency.
Well, I'm sorry, what's the procedural argument being what? I thought his argument is the court failed to determine, as shown by the face of the record, that he has a full understanding of his waiver of his right to appeal, therefore his plea is not knowing, intelligent, and voluntary.
We're arguing that it's procedural and that the actual execution of the waiver was delayed post-sentence. So if he had a problem with the way that...
So you're taking the position that... Let me get this. You're saying the only waiver happened at sentencing?
Well, he was informed of the waiver at the time.
No. When does he waive his right to plea?
Well,
what's the people's position on that?
He executes
to appeal, excuse me.
He executes the waiver at sentence with...
Okay, is that when you're saying he waives his right to appeal?
Correct.
At sentencing?
Yes.
Not when he takes the plea?
He's informed of the waiver at the time of the plea allocution as a component of the plea bargain, but he doesn't actually waive it until sentence, when he executes a waiver with his attorney that he's reviewed with the attorney.
And so what case allows a court to delay the colloquy and confirming that a defendant understands what's entailed and the consequences of a waiver of the right to appeal?
Well, we cited
until sentencing.
We cited case law in our brief that referenced the fact that a defendant could waive his right to appeal after a trial post-verdict.
Before the sentence.
Before sentence.
Now let me go back to the same question I asked counsel. I'm sorry, Judge. I didn't mean to.
After sentence?
Yeah.
To me, it was at the same time. But I think that what the panel's missing is that when the defendant did this at the time of sentence, there's no question that the fact that he's waiving his right to appeal is separate and apart from the other rights that he waives by virtue of the guilty plea. So it's not conflated, which is an issue that is frequently reason to invalidate waivers.
Okay,
in the appellate
okay. So if I'm understanding you, he goes in, he takes a plea. He is, as Acting Chief Judge Pickett has already described, given this go through this extensive colloquy about the trial rights that he is waiving, that he's giving up on that plea. Everybody agrees with that. It doesn't seem to be an issue in the case. It's obvious on the face of the record. You're saying that the defendant could then take a plea and then at the sentence say, and in addition, I waive my right to appeal. So he could take a plea and then at some later point in time waive the right to appeal.
Well, that's what appears to have happened here from the
No, I know that's
the record. So
that, counsel, I'm just trying to get straight
Right.
what you say is the basis by which the challenge here, which is the challenge to the plea, is nevertheless meritless under that scenario. If he doesn't know about the consequences of a waiver of the right to appeal when he takes the plea, then how is the plea valid, knowing, and intelligent?
Well, the waiver of the right to appeal is really, in this case, it's really separate from the arguments that it's not the same as the plea itself.
Well, we've said that in Lopez, we've said
Right.
that in other cases, of course, but when I take the plea, if I'm the defendant, aren't I supposed to know what the consequences are of taking the plea, including my rights to appeal?
Well,
Isn't that what we have said?
yes, but here the result would simply be the invalidation of the waiver.
Well, let me try it another way. Let me try it another way. So he gets to sentencing. Judge goes through this colloquy on the waiver of the right to appeal. And defendant says, I don't give up that right. So do you then, as the ADA, then say, okay, then we are pulling out of this plea? Must the judge automatically allow withdrawal of the plea?
Potentially, they would
What do you
may
mean
have to entertain I think he would have to file a motion to withdraw the plea,
And his grounds would be what?
that he wasn't advised of the consequences of the waiver.
Exactly, that's the point. But you're confirming that he hasn't been advised of those consequences, correct? You've just said that. That was my first question to you.
He was advised of the waiver, but they did the actual colloquy at the time of sentence.
Judge Fate, you had a...
We were talking before about the second department, the questions on that. It seems, that at my count, there are 5 cases in the second department that have held this particular type of procedure to be wrong. What distinguishes this case? It's the same judge, same process. They seem to have...
To be honest with you...
Let me finish.
Oh, I'm sorry. I apologize.
Sorry. It's tough getting it out here. This is a tough crowd. Gil was one of the cases that the appellant had mentioned before. But anyway, the 5 cases themselves all seem to be in front of the same judge in the same procedure. They've held it to be wrong, yet in this one they said the appeal waiver was valid. It's your bird. Why?
I have no idea.
So then let's assume the appeal waiver was invalid, and let's just go to the KVI argument, the real argument in the case.
Right.
Right. Go ahead.
Well, we feel that I'm aware of Judge Pickett's feelings on this matter after having multiple leave conferences. I think I told him that the first time he told me that there was no crime committed, I said I had a cardiac event. And I continue to do so, frankly. But I think that I wouldn't want this court to be misled by statements that this defendant made that were really outside of the record of the plea in his pro se supplemental brief. You know, there's no point in having a guilty plea if a defendant can come in after he's forfeited his his defenses, basically, and said, I'm not going to contest the people's allegations, I'm not going to go to trial, I'm going to plead guilty, and gets a benefit, and then has the chance to go to the appellate division and argue, like, I don't know where he got these facts. They're not my understanding of the facts. I mean, my concern is that if I go into all of the facts, I'll be arguing matters that are outside of the record.
That's right. And, you know, I feel your pain with respect to that. But it just struck me that it was never there. For example, Ms. Mueller, who I think was the executive director, there's no statement from her in the record that I had, because I had the appellate division one. And nowhere, she must have appeared in the grand jury, but nowhere is there any evidence that, probably because it didn't come up till his brief, that what he said was true, that they threw these records out. And I thought, they're the ones that ought to be embarrassed. And then the scenario that at least he developed in his brief really seemed bizarre. And that's why I couldn't figure out what was going on. It's not even argued here. So
I mean, there's 2 scenarios from that. One is that it's bizarre because, you know, he's being picked on and he didn't actually commit a crime. Or the other one is that it's really bizarre and his attorney did the right thing by having him plead guilty before he could go to trial on his so-called defenses and get smacked on a possible sentence of 1 1/3 to 4. So it's really, before I let the court get led down this path, I just want to refer back to the plea allocution where he says, he admits to overreaching. He admits that he extorted money from them. He admits that they weren't his records.
But what weren't not the fence with you over all of this, but he never said he extorted money. That was, I think, the judge put that word in the record, or maybe it was the district attorney, the ADA, but because he kept talking about however this thing unfolded, and no one refuted it. I guess that's what kind of got me going. It gave you a heart attack.
It did. Well, the thing that is that there's no doubt that this is a very vocal defendant, and he is intelligent. And when the court was going through the allocution, and his attorney said, you know, on the record, I believe my client understands that he extorted money and he broke the law, and there is no Robin Hood defense, and the court affirmed him, yes, that's correct, there is no Robin Hood defense. He doesn't say anything, and he never moves to withdraw the plea on the sufficiency of the allocution. His 440 motion wasn't filed until after his conviction was affirmed in the appellate division, so it couldn't preserve any of the issues that he's trying to raise here. I mean, to me, there's nothing in the plea allocution that renders it involuntary or invokes the Lopez exception.
No, I was interested on the extortion question. The judge does what everybody does, is he read the charge sheet, basically, and the way I read it, it says that you did attempt to steal properties valued in excess of $3,000 from the GHVFHC, and that you did this by means of attempting to extort property. Question, you admit that question? And he says yes. So
Correct.
he doesn't directly admit it, but
Right, but he
use a word, but he agrees with what the judge is saying.
Right, correct.
Wasn't that strange? I mean, the 3,000 hit me. I realize it's a threshold thing, but the way he told the story, if she said, you know, we'll write you a check for $1,000, you would have accepted that.
I don't think that's really what happened here. I think that this entire scenario was his creation, and you know, his attempts to explain on appeal what happened as, you know, a stipulation, a settlement, and, you know, we had this agreement. That's not what happened at all. He did everything but, you know, put a gun to their heads. And then he, you know, if someone forces you to sign a contract, that doesn't necessarily mean you can enforce it. And there was an attorney in the appellate division who did the same thing and was disciplined. So I don't know. You know, I think we feel affronted because we feel like he got the benefit of his bargain, and he said he wasn't going to go to trial on this, and now he's coming back and saying, well, this was really a contract. Well, if you thought it was a valid contract, you should have gone to trial.
Yeah, that's what we wonder. Well, thank you, Ms. Schultz.
You're welcome.
Mr. Feldman, you have 2 minutes.
Your Honors, just 2 quick points, just so there's no confusion. My understanding of the people's argument regarding the appellate waiver was that that could be unpreserved. And this Court and
Where does it get you? I mean, so if we agree that the procedure here and that the waiver of the right to appeal was invalid and ineffective, does that render the plea involuntary, or does that just enable reserve for the defendant his appeal rights?
Correct. The latter.
Okay. So if that's the case, then doesn't it still have to be preserved, his argument, unless the Lopez exception applies?
No. There is I'll tell you why. There is a body of federal case law enunciated by the First Circuit Court of Appeals as of, I believe, 2014, which talks about appellate waivers, and if there is no objection, it will be reviewed for plain error if a challenge is raised on appeal. In New York State, no court has ever talked about non-preservation with an appellate waiver.
Well, if there was never a waiver of the right to appeal here, if they didn't even talk about the waiver of right to appeal, it wasn't a part of the bargain, then aren't we at your argument on whether they negated an element of the crime?
Yes.
Okay.
Because
so
one is procedural and this is on the merits.
I don't understand why the waiver of the right to appeal has any effect on what we're doing here.
Because if the waiver of the right to appeal is enforced, he would be barred from addressing the merits in point 2 of the brief.
Well, how could it be barred if it goes to the voluntariness of his plea? The waiver of the right to appeal doesn't bar
Right.
a challenge to the voluntariness of the plea. So again, I don't understand the effect.
That's correct. A challenge to an appellate waiver based on voluntariness survives the appellate waiver, but there's a little twist on that because we're also arguing that the appellate waiver wasn't knowing and intelligent, which is slightly different than whether it was voluntary. And we're just touching all the bases to make sure that the post-plea appellate waiver is found prohibited because a defendant has to know all of his rights ab initio and not at sentence when it's too late.
I think we have your argument.
Thank you very much, Your Honors.